Hey, welcome to today's video. I'm Rick Chapo with DMCAagentservice.com. So today we're taking a look at false DMCA consequences. So what is a false DMCA? It's a DMCA takedown notice that is sent for inappropriate reasons. So DMCA takedown notice is supposed to be sent when you have copyrighted material that is somebody else is using without your consent. So for instance, let's just say I write a 5,000 word blog post. Yeah, that's going to happen. But let's just assume that I did. I posted on my site on dmcaagentservice.com. And a couple days later, I do a copyscape search and I see it on another site. Okay, I haven't given them permission for them to use my blog post. So I would hunt down their host and I would submit a DMCA takedown notice because what they're doing is copyright infringement. Now, DMCA takedown notices are badly abused online. We see them used for all kinds of inappropriate reasons. Some are strange, such as submitting them for trademark infringement cases. In other situations, they're nefarious. They might be used as part of an extortion scheme, or they might be used to try to find out who the person is that posted the original content and where they live. There's just all kinds of nasty little uses. And the question is, well, what are the consequences of that? What if somebody misuses it, whether it be an individual or a company? And we have to look to the DMCA code. And I know you're just dying to hear about the legal language in the code, but we have to deal with it anyways. So the solution is found in section 512F of the copyright code in the DMCA sections. And basically what that reads is misrepresentations. Any person who knowingly materially misrepresents under this section that material or activity is infringing shall be liable for any damages, including costs and attorney's fees incurred by the alleged infringer. So what we're talking about here is that if somebody knowingly, materially creates a false DMCA notice and submits it, then they're going to have to pay for any damages, including costs and attorney's fees, that the alleged infringer suffers. So that sounds great, doesn't it? Then why aren't we seeing all kinds of abuse lawsuits, DMCA abuse lawsuits? And the answer is the legislature did a poor job drafting the language, and they created a real problem in the court system. So if we go back to F and we read that first line, it says, any person who knowingly, materially misrepresents. Well, under legal theory, that is interpreted to mean that the party who is submitting the fake DMCA notice has to essentially intentionally be doing so. You have to be showing that they knew that they were doing that and that they went ahead and did it anyways. Now, if that person can show that they just made a mistake, well, that doesn't rise to the level of knowingly, materially misrepresenting. And as you can imagine, what happens in these cases is the defendant suddenly becomes very apologetic. And they say, you know what? I apologize. I made a mistake. I shouldn't have submitted this DMCA takedown notice. I didn't realize this is how the DMCA works. It wasn't malicious. I just made a mistake. And a mistake is negligence. It is not knowingly, materially misrepresenting. Now, are they telling the truth? Well, that's between them and their God. But unfortunately, it's very, very difficult to prove in court because you're not saying, well, what would an objective person have thought when they submitted this fake DMCA takedown notice? You're saying, what did this person think? And there's a good chance they're going to play stupid. I didn't understand, and that's a hard burden for you to overcome if you want to sue somebody for that. Now you can sue, and certainly, a lot of people have, and there have been some lawsuits out there, and they usually don't end up very well. Now that doesn't mean that it can't prevail, that you can't prevail. There's a case right now that is making a lot of news. That's going to be very interesting to watch. Is YouTube versus Chris Brady. And this just came out a couple days ago. So YouTube served Chris Brady with a lawsuit for DMCA abuse in federal court in Nebraska. And what YouTube is alleging is that Brady was essentially running an extortion scheme against certain YouTube YouTubers, people posting videos on YouTube. And what they're alleging is that he told them something along the lines of, you either give me money or I'm going to start filing DMCA takedown notices against your channel. And the reason why that would be considered a threat is that if a channel receives a certain number of successful DMCA complaints within a certain period of time, YouTube will close the channel. And that's not because YouTube's being a jerk. The DMCA requires that. It's a concept known as the repeat infringer policy. And usually, 3 or 4 complaints will result in the channel being closed. Well, for the people who are posting those videos, posting to those channels, a lot of them, that's how they make their living. So if the channel is closed, well, they have a big problem. And so you can see why people might respond by paying. Now, of course, we only have the YouTube complaint, so who knows what the evidence will actually show. And Mr. Brady certainly deserves his day in court and the right to present evidence contrary to what YouTube is claiming. But, would this give grounds for a 512F action? And would it be successful? If YouTube's allegations are correct and if the evidence supports them, then you would think, yes, it would. Because it's going to be very difficult for Mr. Brady to claim that extortion was negligence. When he's sending these either emails or messages, I don't know what it is, to the YouTubers, demanding money. Well, I'm sure they printed out or created screenshots of those messages. They better have. And how do you negligently extort money from somebody? I mean, you're either doing it or you're not. And so, again, this assumes YouTube's complaints and, the allegations are correct, which haven't been proven. He's innocent until proven guilty. But you can see how at that point we have evidence that shows that it's not just negligence. It wasn't just a mistake. That is a knowing misrepresentation, again, if the evidence supports it. And so in that situation, the YouTube infringers could actually sue as well. So can YouTube, and they could recover damages. Now, what are the damages? The damages are whatever the injury is to the person who is bringing the lawsuit under 512F, including their costs and attorney's fees. So in the Brady case, what are the damages? Well, to YouTube, there really aren't any damages. I don't see how YouTube was actually hurt by this, but they're going to be able to recover their costs and their attorney's fees. So why would YouTube sue? What do they care? Well, obviously they want to stop this kind of practice going on because it could affect just the stability and the credibility of their entire service. Now, the individual YouTubers who are impacted by this could also sue. And in their case, there may well be a bigger damage claim because if their sites were, taken down or anything of that sort for a while, then obviously there would be damages. Now, what happened in the facts of the case is that YouTube, figured out what they think is going on, and they removed those strikes from the accounts of those YouTubers, and their accounts are fine, the YouTubers are fine, and so now it's just really between YouTube and Chris Brady. So anyways, it'll be interesting to see how that case plays out, but it is an example where somebody could certainly be caught red-handed. Now, there is another area here that is sort of up for debate, and that is software. So a lot of larger companies, they don't have time to pay people to sit and just, browse the web looking for copyright infringing material. So they use software. And the software will go out and look for keywords or, markers or whatever it is, and then submit DMCA takedown notices. And the question would be, well, in a lot of occasions, those notices are inappropriate. They just are. And so is that going to rise to the level of a knowing misrepresentation by those companies, knowingly, materially misrepresenting standard or not? And we don't have an answer. So it'll be interesting to see how that plays out. But anyways, so false DMCA consequences. Are there any? Yes. Under Section 512F, you can sue the party who has filed a false DMCA takedown notice against you. Are the cases easy to win? No, they are not. And so you're going to find a lot of attorneys are going to be hesitant to pursue them unless you're paying on an hourly basis because, again, they're just difficult to win. But anyways, you might want to keep an eye on the YouTube versus Chris Brady litigation, maybe do a Google alert or something of that sort, because it'll be interesting to see how that plays out. So anyways, if you have any questions or comments, post them below. If you enjoyed the video, consider giving me a thumbs up. If not, thumbs down. If you're interested in DMCA issues, we post hundreds of videos on the DMCA. So go ahead and subscribe to our channel. And of course, if you need a DMCA agent for any reason, visit us at dmcaagentservice.com. Thanks for watching. Have a good one.